So Matt Strasniak helped me set this up with Steve Hill, and we're just so glad that he's here. First of all, got to acknowledge the sponsors and all the people who helped make this happen. Tony with Performance PC is kind enough to live stream these events, and he can build live streaming systems, and he also can go out on location and do live streaming. And you guys, all of you in video who are not into live streaming, you should think about getting into it, because it gives you some recurring revenue, and it's one of the few things that when you talk to your clients about having live streaming, it's a profit center. They're not spending money on you. We have one association that we've done it with for a long time. They've gone from 12 members to 200 members. They've been able to charge like $50 for membership rather than 25, and they're just growing by leaps and bounds. So it's not just that, it's all the innovative things they're doing, but it's a great thing to be able to pitch to people. So just know Tony with Performance PC, and Copy Talk is one of our sponsors tonight. They provide video transcriptions, and also for, like, if you guys do interviews and you need transcriptions of your videos or interviews or anything like that, and then also for closed captioning. And of course, we want to thank Robbie and Michelle with Video Van Gogh or Van Gogh Studios. They have this awesome facility. They also have a green screen we've rented from them. They are great people to work with. They have a beautiful facility, and they are getting into doing a lot of webcasting and training and those kind of things, and they want people to come here. So you can rent their studio. You can also come here and do live webcasting, which is just such an exciting thing for the future. So I think that's all the thanks that I need to give out. And then, of course, I'm Donna Davis with the Atlanta Internet Video Marketing Association, and founded this to be able to help all of us keep up with all of the demands that, as video producers, we're having right now. And so thank you for coming. Thanks to our live audience for being here. And I want to introduce Steve Hill. And he deals with great clients. I'm just so thrilled that he would come here. His client list includes Hooters. He's an expert in intellectual property law and copyright and trademark. Yeah, Hooters is probably not your. I mean, he's got lots of.
Well, that's obviously the number one I want you to throw out there for starters, before we even get going, to establish my bona fides.
And I know they really needed a lot of help too. They're one of our clients as well. So we are just so thrilled that he's here. He's been written up in so many journals and that kind of thing, and very recognized as an industry leader. So we're just thrilled to have him here. So thank you. And when we do open it up for questions, if I can ask you guys to come to this microphone, which will be on that stand. Thank you.
All right. Thank you. The Hooters comment notwithstanding, I am very pleased to be here, and I want to thank Donna and thank the Atlanta Internet Video Marketing Association for inviting me. Our law firm has, for the last 15 years, been to some extent devoted to the proposition of a rapidly expanding internet and what that means for intellectual property. But I personally was dealing with these issues even as a young law student, coming out of law school in 1994 and moving to Atlanta at a time when associates in law firms didn't have internet access, and we certainly didn't have email accounts and things like that. So I literally have watched before my very eyes, in a manner of speaking, the stress that the internet or information superhighway, as it was once described, has put on the core principles of copyright, patent, and trademark. And that's right, I said copyright, patent, and trademark. We're going to be talking about copyright, but I think before we settle in on the basics of copyright, it's probably important to disabuse some people of the notion that you copyright a name or an invention. Inventions are the species of intellectual property that we would commonly refer to as being patent-driven, while names and brands fall in the trademark sphere. Copyright, it relates to works of authorship by Section 101 of the Copyright Act. And so it's really focused on authors, the creation of works by authors, and to some extent, the manner and methods that are used in order to take some or all of those authored works by persons who are not authorized to do that. So we get into all kinds of issues, and I'm going to go through some of those building blocks as we go through. But before I get there, I do think it's important to think a little bit about the road that we've traveled to get to this point. I can remember as a young lawyer in 1996 going to the first ever Internet Law Institute. And at that institute, the question was posed whether or not the Internet was the death of copyright law. The reason being that there were certain persons who foresaw that the proliferation of material on something as broad and ubiquitous as the Internet is would make it virtually impossible for any content owner to police. And in some ways, I think those predictions were and those questions were well-founded. In others, I think we see that intellectual property law and copyright law specifically has always found a way to adapt itself to the challenges of modern technology. We remember, for instance, that Napster posed one of the earliest major challenges to the Internet and copyright law. The focal point in that case was the P2P file sharing that Internet did for music, and whether or not that represented a modern day version of copy. In that case, Napster was hailed in some corners as a proponent of copyleft, and that we were turning directions with the Internet. And of course, unfortunately, for those in that copyleft camp, we learned that copyright law would regulate entities like Napster just fine, and Napster eventually went out of business. And of course, there were all kinds of highly accredited legal journals which posed all kinds of questions about whether or not Napster was just the start, and whether or not eventually the web would stress copyright law to the point that the law itself would have to yield in favor of unbridled copying of media in cyberspace. And of course, we've seen something of the opposite of that. And I've put up a couple of examples on this slide of recent cases where we can see that copyright protection is alive and well on the Internet. I'm reminded of the mp3.com decision, which was, I believe, 120. Judge entered verdict against mp3.com for file sharing. There have been numerous instances of large copyright aggregators such as Sony and others in the recording industry, Motion Picture Association of America, who have been able to literally shut down websites that have proliferated content that they owned copyrights to without their permission. And it's sort of been incumbent upon visionaries seeking to bridge the gap between media distribution and the desire for there to be a free flow of media distribution on the web, and adherence to copyright law, mainly by the owners of those intellectual property rights who are looking to receive royalties and not have their royalty bases undercut because access becomes free in a particular media channel like the Internet. And those visionaries would include persons like Steve Jobs, with the vision that he had in 2003 for the iTunes Store, the work that went into lobbying with the recording industry for groundbreaking license agreements that would allow the iTunes Store to make a lot of that media available at a very low price point with a fairly broad set of user rights. And that is really, I think, where the magic of the Internet as it relates to copyright has taken place, is that it has the Internet has found a way, and the proprietors of major websites on the Internet have found a way to work with the system, and they have found, in some instances, as we'll see, better ways of dealing with copyright-related conflicts, I think, than what the traditional court system affords copyright owners. And as a result, it's a better system in some ways than the system that we traditionally have, which is one of copyright owner gets upset at copier. Copyright owner may or may not send a letter to copier. Copyright owner then sues copier if copyright owner is not happy. In the internet, as we'll see, there are faster, less expensive ways of dealing with these situations that have risen up through relatively grassroots movement and with a little bit of help from Congress. But mostly it's been indigenous to the web designers themselves, from the website proprietors themselves, seeking to find a better way than being taken to court every time someone on a website that they're affiliated with or sponsoring or providing ISP services to decides to put up content that is offensive to a motion picture company or a recording industry affiliated company. But now that we've kind of talked about these principles that are specific to the internet, I want to take a step back and let's just talk about a couple of fundamental things to any business that's operating in a copyright-centric world. Video certainly would be one of those. There are some popular myths about copyright, and one of my favorites is that if you don't have a registered copyright, then you don't have copyright protection on your works. Totally false, right? The only thing that registration gets you is it gets you a ticket to be able to file a lawsuit, and if you register before you suffer any infringement of that work, it gets you a claim for statutory damages and the recovery of attorney's fees should you ever need to enforce that copyright. The idea that you have to register every work that you create as a prerequisite to owning the rights of authorship and copyright in that work is completely false. So take that for what it's worth. Next myth. Innocent infringement is a defense to copyright. If I've heard that once, I've heard it 1,000 times. It's not true, right? You don't have to know that you're usurping someone else's rights in order to be held strictly liable for copyright infringement. However, innocent infringement can reduce the amount of damages that someone can recover against you. And in my experience, having tried copyright lawsuits to juries, it is a major factor that will be taken into consideration by the jury as they assess the issue of, okay, maybe there was infringement. Now, what am I going to do about it? Certainly, if you were going to ever infringe, better it be innocent than willful under the current copyright scheme. Another issue that you should be aware of is that there are certain circumstances when you are drafting agreements where if you are drafting with someone else that is feeding you content and you aren't aware necessarily of what is theirs and what they may be mixing theirs with in the way of works of others, you should always try to protect yourself through agreements that put the liability for any infringement back on the party that is providing you with the content. That is what we sometimes refer to as a warranty against intellectual property infringement. Sometimes it's also referred to as an indemnity provision against intellectual property infringement. And I would say that applies not just with respect to copyright, but probably across the board with respect to copyright, trademark, and patent. Next issue, since many of you are no doubt independent contractors on some of the jobs that you work on, is when is what I'm doing mine and when is what I'm doing for the guy that contracted me to do this work? Very commonly encountered problem. And I'll give you an example of a case that I had a few years ago where I represented a photographer who, unbeknownst, had taken thousands of pictures in various contract agreements with a particular major magazine publisher, only to find out that all of the pictures, or at least a couple of thousand of them, were up on the magazine publisher's website without his permission. So he goes back to, with the assistance of able counsel, of course, to his contracts with that magazine publisher. None of them provided any guidance as to who owned the copyright in the works. The magazine, of course, had the right to use the pictures in the bricks and mortar magazines, but it was silent as to what, if any, rights they had to use the pictures on their website. So, after a few failed attempts at negotiation, this photographer took all of those photos, registered copyrights in them with the Copyright Office, and successfully sued the magazine publisher. Now, why was he able to win that case? It's because under the Works for Hire statute, which is a subset of the copyright law, the work that he was doing as a freelance photographer was presumptively his to own. The copyright in all those pictures he took were his to own. As a result, he had the contractual right to control what the commissioning party, in this case the magazine, was able to do with those works. And if it didn't specifically say that the magazine publisher was able to use that content on their website, then they were out of bounds. They were working outside the scope of their license agreement, and they were infringing his copyright. Moral of the story is, know your rights when you sit down to draft these agreements. If you are contracting with another video producer, know that in the situation where you are silent in the agreement about ownership, they may try to claim that they are the owner of the copyright, that you have limited rights and no rights to use the content they give you for any purpose other than the limited purpose that has already been discussed between the two of you. Now, there is an exception in the Copyright Act for motion pictures and some audiovisual works. But the good rule of thumb, if you're negotiating as the commissioning party, is always make sure that you have a work for hire provision in there that says that you are going to be the owner of the copyright in whatever your contract worker is going to produce. Okay? By extension, if you are working as a contractor, push back as much as you can within reason to work for hire provisions, or make sure that you have negotiated as best you can a range of rights for yourself to continue using the works that you're producing. On the internet, in connection with internet and allegations of infringement, I hear the phrase fair use all the time. It's one of the most overused terms in copyright law. Fair use is designed to be a limited exception to copyright. But the way some people use it in chat rooms and in the blogosphere, you would think that fair use is the exception that swallowed the rule. The reality is it's not, unless perhaps you're a university professor making copies of things to incorporate in large course packs for students. Keep in mind the fair use, the underpinnings of fair use had to do with things like education, research and development, and parody, as well as criticism. So if you needed to quote from a book in order to write a criticism of the book or a book review, then you would get some leeway, right? And in literary terms, I often hear this 10% rule of thumb. I don't know if it's really true or not. I haven't really ever seen a case that bears that out, but I frequently hear the 10% rule of thumb from people on the literary side of copyright. Don't know where that came from. I can tell you that there's a Supreme Court case where the Nation magazine took 400 words of the unpublished manuscript of Gerald Ford's autobiography and put it in a small article about Ford that they ran in the Nation, and they were held to have infringed copyright, notwithstanding the fact that the book itself was tens of thousands of words. They took 426. No fair use. So rules of thumb in fair use are dangerous. The thing that I look at in fair use as a lawyer, and that I would advise clients to look at, is how transcendental is what you're doing with the work in question. In other words, are you taking a little bit from here and taking a little bit from there and creating something that's new and exciting? Or are you copying a small bit and putting it out there and basically reproducing it without creating something that's new with it? Another common myth amongst laypersons is that if I don't charge for it, it must be fair use. Not true. You take someone else's video content and put it on your website without their permission and don't charge for it, and you are not going to be you're not going to be heard to make a fair use argument in any court in the country, because unless in only the cases where you are running a nonprofit and where the use that you're making is so slight and de minimis of the material in question would you ever even have a chance. It's not enough not to charge. So one thing that people should probably appreciate is how serious are the risks, right? What happens if I do something inadvertent and somebody comes after me for copyright infringement? What are we really talking about here? Well, we're usually talking about one of two things. We're usually talking about either actual damages and profits that have been deprived the copyright owner by virtue of your use, or in other instances, the copyright owners will elect what's called statutory damages. Now, we saw in the earlier slide, there's no statutory damage claim unless there's a registration of the copyright that precedes the infringement. And in 20 years, I would say it's roughly 50-50. I see cases all the time where there's no registration until there's infringement. And in those cases, there's never statutory damages claims, only claims for actual damages. And the statutory damages scheme, as you can see, is not punitive. Statutory damages are tested on a range. Unless it's willful, meaning you knew that what you were doing was representative of an infringement of the other person's copyright and you did it anyway, you're talking about $750 to $30,000 at the high end. And that is per work infringed. It doesn't matter if you make 1 million copies of the work or 20. The statutory damages for that infringement will be tested in the $750 to $30,000 range for non-willful infringement. And of course, with regard to the statutory infringement, as we go back to this question of innocent infringement can be used as a defense which, if proven, can drive the statutory damages all the way down to $200 for infringement. Now, you may be in the audience right now saying, why would I pay Steve Hill $100,000 to defend me in a copyright case where at the end of the day I may only owe $200? It's a very good question. I don't have a great answer for that question. The better cases for copyright are the situations where there is real actual damage and additional profits of the infringer. And I can tell you that in addition to additional profits of the infringer, you can also pursue a claim for disgorgement of profits that have been realized by the infringing activity itself. So I'll give you an example of a recent case that we tried. It's a case where we were representing a consulting firm that did sales management consulting to the furniture industry. Basically, they wrote manuals and they licensed those manuals to major furniture retailers around the country so that they could train their sales staffs with them. A national furniture retailer got its hands on their sales manuals and decided to create an illicit training program, trained 64 salespeople with unauthorized copies of our clients' manuals. At trial, we didn't really have any actual damages to speak of. We had, of course, the lost licensing revenue that we might have been able to obtain if they would have come to us and done it the right way. But we knew those dollars and cents from our prior history of licensing would have been thousands of dollars, not hundreds of thousands or millions of dollars. So instead, we asked the jury to give us 40% of every profit dollar earned off of every piece of furniture sold by every one of those 64 salespeople who were trained. And guess what? That's exactly what we got. $1.89 million, representing the profits that were earned by the infringing activity. So that, of course, costs money and time and takes years to go through. The question for people who are doing a lot of work with the web is, what if I don't want to go through all of that? What if I don't want to pay lawyers? What if I want to use more self-help? What's out there? And what do I need to be aware of? And what can come back and haunt me if I put something up on the web in the way of content that I don't have copyright to and I don't have a license to? The answer is there are at least 3 processes that I want to make sure that you're aware of. 2 of them are quasi-legal, and the third is purely preventative. The first is the Digital Millennium Copyright Act, HAMR. And that is, for the unsuspecting person, if you put something up on a website that is sponsored by a particular particular internet service provider, particular domain provider, you can go over the head of the website owner that is misusing the content and write to a higher level authority on the internet, bring the infringement to their attention, and they have a limited period of time under law by which to remove that content, see to it that links to that content are completely disabled from their search engine, if that's, in fact, if you're writing to Google, if that's what you're talking about. And if they don't do it, they now have knowledge of the copyright and they can be said to be assisting with the infringement, co-liable as an inducing infringer. The Supreme Court looked at this several years ago in the case of Grokster and said, yeah, even though you may not actually be sharing files yourself, you could be facilitating it. You can encourage infringement in a variety of ways online. And because of issues like that, the large reputable companies on the internet are completely paranoid about their potential liability for infringement, and probably even more so, just the potential of being hailed into court and having to pay lawyers to defend themselves, because they know they're not judgment proof. They know that unlike the guy that may be that may have proliferated your content without your permission online, they actually have resources and they can afford to pay a judgment if a judgment against them is entered into. So they take these demands very seriously, and assuming that you can prove your copyright with a copyright registration certificate or other indicia of authorship, they're going to take that material down or see to it that it cannot be accessed online. Specific example of this that's drawn a lot of fire in the media is this YouTube Content ID system. Although if you get into YouTube, they have probably the singularly most sophisticated approach to regulating copyright of content on the web. The Content ID system is the thing that I think is the most meaty subject for our purposes, so I'll tell you just a little bit about it. As a copyright owner, you can submit digital copies of your media, audio-visual media, and it goes into a registered database that YouTube has. Anytime someone uploads content to YouTube, it is automatically cross-checked against that database. If there are match points in your media, then it's automatically flagged as a copyright infringement. And the thing that really is surprising about this system is not just that it kind of works on this guilty until proven innocent mantra, but they allow you as the copyright owner, you get an automatic notification of the fact that someone has uploaded content. And you have the opportunity to select to monetize the ads that run on their video. So instead of the guy who did the work to produce the video, who's looking at getting 55% of the ad revenue for posting it up on YouTube, with YouTube taking the other 45%, you suddenly can find out one day that your paycheck is going to somebody else because of a content ID match where there's not been anyone at YouTube, no person at YouTube has actually looked at this situation to see whether or not it's meritorious. No one has evaluated the issue of fair use. No one has made a single humanistic determination of right or wrong here. And yet the money is changing direction and being rerouted. I think that's a really interesting development. It's gone way farther than any other major player on the web has ever gone with respect to their content policies. The last thing I want to touch on briefly is the notion of digital rights management and encryption, because you know, in the era of things like the iTunes Store, where you're buying essentially use rights to media, you need to understand as a content maker that DRM can, in certain circumstances, be a really resourceful tool for you in avoiding infringement situations. You can use DRM technologies, you can use encryption of files, you can use the notion of license rights and watermarking files for particular uses only in order to control what anybody else can do with that file unless they have your express permission and the decryption keys to be able to actually manipulate those files freely. That is why when you rent a video at the iTunes Store, you got to watch it within 24 hours or else you lose, you try to watch it in the 25th hour and you're surprised to see that the file is no longer enabled on your PC. That's because DRM allows a very complicated set of usage rights to be programmed into the files themselves. And without the proper usage rights, you will be unable at some point to access the media in question. That's all I got. Questions?
Anybody who has a question, please just come to the microphone right there so that everybody online can hear as well.
She said I had to be done in, very quickly, so I apologize if this was rapid fire, but I wanted to make sure that we left some time in case there were specific questions.
Hello, my name is Tina Pegram. My question was, how can you be, shared in copyright infringement online? How can you be accused of sharing?
Well, there's two theories. One is direct infringement. So if sharing party A, somebody has to have a file, right? And the file itself, the presumption is that sharing party A is someone other than the copyright owner, right? So let's imagine, for the sake of argument, that I have purchased an episode of the series 24, since I'm a 24 fan. And I have that, and I drop it to a thumb drive, and I say, you really need to watch this episode of 24. So I share it with you. Now you upload it onto an unauthorized, for an unauthorized usage that's outside the scope of what I agreed to per the terms of licensing on the iTunes Store. Their point is, if you want to watch 24, come to the iTunes Store and pay the $2.99 to get your own usage right. Don't circumvent. So that's really where the argument comes in. I'm liable because I own the file that I'm sharing with you, and I don't have permission from its true copyright owner to hand it over to you. You're liable because you're contributing to the unauthorized distribution by accepting the unlawful copy. If this is done on a website and the website owner has knowledge of it, Under the Grokster decision, he too is probably liable, unless he has a good faith basis for believing that the activity in question was not truly copyright infringing. And I'll give you an example. If we were talking about a music video where there was a lot of sampling going on, and in a 3-minute music video, someone had 5 seconds of one of their songs sampled into the music portion, that music owner might not have a good case to bring against you or I if they tried to enforce just the music rights copyright in that file sharing situation. If the proprietor of the website was aware that that's what the situation was, they might have a good faith basis for believing that what was taking place was a fair use exchange between you and I, in which case they would avoid liability under Grokster.
Thank you.
I have a question. I don't know if it falls under copyright. I work for a digital marketing agency, and one of our clients is a LASIK surgeon. And we found a video online of a person who is not a patient, who is using the business name and the doctor's name to basically say that LASIK ruined his life and made him blind, and LASIK was horrible. And he's doing this to lots of other doctors. And we weren't sure if that fell under fair use, like a parody, or if it fell under slander.
One of the things that it's tough when they say the word expert before you take the podium, because you feel like you need to have the answer to every single issue in the entire field. And what I'll tell you is, this particular situation, I think, may fall slightly outside of the realm of intellectual property, because the person who puts the video up in that case typically produces it themselves, so they're the author of the content. Then you're focused on the words themselves. Okay, so assuming that the person on the video wasn't working off of a script written by somebody else, there's really not a copying issue. There's nothing that he's copying. Okay, so then you say, okay, so he's using the name of the eye doctor in question, the name of the clinic possibly, and the doctor in the clinic may have rights in the name, right? So is it trademark infringement? Probably not, because of what trademark law refers to as nominative fair use. If I'm a newspaper editor and the New Kids in the Block are having a reunion concert and I want to write an article trashing the New Kids on the Block, I've got some journalistic license to be able to do that. I think in the situation where you're not really panning, but you're actually criticizing, I think you're now moving outside of intellectual property to a question of how legitimate are the statements that are being made. If there's falsity to them, then it may be portraying the physician or clinic in a false light. That could be a tort claim. It may be that it is slander or libel or business defamation, right? And those all fall kind of outside of my general expertise, so I can't really go much farther than that.
Thank you.
Yeah. Oops.
I'm Barry Sermons, and I have a question on behalf of my church. And so on Sunday mornings, we play all kinds of music. And it's not the original version. We have a band. And so the band would like to know, and we do stream our services and have been for the last 4 years. And so the band would like to know, have the laws changed? What are they now, and what should we be looking out for?
The thing that is the most important thing that you said, Barry, in your question is that this relates to your church. Okay. Because in my experience, content owners are loath to pursue nonprofit organizations, including but not limited to churches, for infringement. Okay. Of course, there are avenues out there. There are copyright clearinghouses for music that can be researched and approached in order to obtain a license for that kind of production activity. absent a license, yes, technically, you could be in a copyright infringement situation.
So what I'm hearing is that if we contact like ASCAP, BMI.
ASCAP,
or-
BMI, Copyright Clearinghouse.
Okay,
Yeah.
okay. Thank you.
Those are great places to start if you're looking at trying to get a package music license. And as a nonprofit, I suspect the pricing is.
CCLI.
CCLI.
Christian Contributory Licensing will give you it covers ccli.com.
Okay, thank you.
Even, so that sounds good to me. And I'm dying to know what church, but I'll talk to you offline about that. I'm pretty sure the church I go to does that too. That's why.
I'm Linda Grani. I run PD Info, the Public Domain Information Project. We have to deal all the time with background music, and we license background music. And so theoretically, essentially every sound recording ever made is under copyright protection until 2067. But there are all these websites out there that say, like there's a Bessie Smith and a Scott Joplin, and they go back that anything 1978 or earlier is not covered under copyright law, but it's covered under state law, and it's even better covered. Bottom line, comment on public domain sound recordings. Are there any? How do we identify them? Can you give me any input on public domain sound recordings? So there are millions of public domain songs.
Right. Okay. I consider this a law school final exam question in copyright.
I answer it every day.
Right. So you probably know that the Sonny Bono Copyright Extension Act, which is also sometimes referred to as the Mickey Mouse Copyright Extension because Steamboat Willie was about to expire at the time that this Extension Act occurred, and so Steamboat Willie and a whole bunch of other Disney copyrights got prolonged in their lives. Prior to the Sonny Bono Copyright Extension Act, which I believe was passed in 1998, the scheme that we were under was pursuant to the Copyright Act of 1978. And under that scheme, as I recall, and you probably know the dates better than I do, if you were an individual, if it was a copyright that belonged to an individual author or the heirs of his estate, it expired 50 years after the death of the author. If it was a copyright work that was owned by a corporation, I'm going to say 75 years, but I may be off on that. The Sonny Bono Copyright Act took all of those works, including works which were set to expire, many of which had carried over from the earlier Copyright Act of 1919, which is a little bit before my time. And it extended the 50-year term beyond an author's death to, I believe, 75 years, or 70 years. And for corporate-owned works, it also added, I believe it's now 90 years.
Bottom line, for people in this room, are there any sound recordings they can just go out there and get?
Yeah,
That's
Beethoven, Mozart, anything that probably was authored.
No, we're not talking about song, we're talking about sound recordings.
Right, but there's still, authored meaning recorded.
Okay.
In this case. Anything that was recorded, well, it's a harder question than that. You need to know in each case, is it owned corporately or are the copyrights still owned by the family, by an heir? And you need to then be able to do the math of how long it's been since that person would have died. What you need to know is prior to what had expired prior to the 1978 Copyright Act. To be safe, I wouldn't be looking at works from the 20th century. I'd be looking earlier.
We use a lot of music in our video production company from royalty-free sites, but from what I understand, that's not even completely royalty-free, is it? Like, what kind of issues might we ever have for that?
Well, the worst part of the so-called royalty-free anything on the internet is that there's no verification process. So it's very common these days for people to get caught in the sticky wicket of they see something on the web that is claiming that it is royalty free or claiming that it is through a free clearinghouse. And they say, oh, I can grab this. And they either cut and paste it onto something they're doing, or they clip the music file and they put it on their site, and then they're surprised when they get a letter from the owner of the copyright, and they say, wait a second, you know, I took this from a royalty, you know, it had the insignia of a royalty-free organization on it. It was and often people are disappointed to find out that the people that are putting that content up to begin with are just using the royalty-free designations as a way of trying to cover their own rear ends and trying to disguise infringement, as it were. So, of course, you know, a phone call or an email to the organizations that are supposedly being the sponsors to actually verify that they have the rights to sub-license that material to you, very valuable in that context if you're really trying to make sure that you've dotted your I's and crossed your T's.
Yeah. Anybody else have any questions here?
You had touched on it before. My name is Otis Tillman, but you had touched on it before, and I just wanted to clarify it because I was reading it on the internet. If you create a piece of art, photography or whatnot, and you were saying that you don't need a copyright per se until your rights are infringed, could you, if I drew a piece of work, put it on the internet, and I look up and somebody has infringed on my rights, then I go file a copyright, or? Could you elaborate on it a little bit more?
I can and I will. There's actually two myths that I might as well disabuse the audience of when it relates to this issue. Because the other one that I hear that I didn't deal with in the presentation materials is that if I don't put a circle C to indicate a notice of copyright, then I've forfeited my copyright. Okay, that was once upon a time that was actually true, but the United States now participates in the Berne Convention. So whether you put the circle C on your material or don't put it on your material is academic, and it's inconsequential to the question of whether, as the author of that material, you own the copyright in it. By law, you do. You own it from the moment you create it. So registration is an option. It's not a responsibility. Okay, now as a practical matter, registration is inexpensive. So if you choose to do it, it's probably less than $50 to register most works with the Copyright Office right now. But as a practical matter, I don't see very many people coming to me and saying, will you help me register these copyrights? The reason is because the only thing that registration gets you as an absolute right is a ticket into court in the event that you're suffering infringement. If you don't think that infringement is likely at the time or near the time that you're creating the work and publishing it, then I would say trust your instincts on that. If you don't think that it's something that that people are going to be tempted to steal and misuse, then you're probably right. And registration is probably something that you can put on the back burner until and unless you actually have a consequential infringement issue come up.
Okay. And what would happen if that issue did come up and I didn't register?
If it comes up and you haven't registered, what you are losing is the ability to chase that statutory damages remedy. Remember on the slide of $750 to $30,000, regardless of whether or not there's real economic harm associated with the infringement, right? So you're walking away from that, and what you're left with is a right to pursue the actual damages or the profits that you've lost because perhaps they used your material to get a deal that you otherwise would have been a candidate for, or you know, like the case that I had with the furniture sales materials, where they were able to disgorge the profits that the furniture company realized by using their copyright materials without their permission.
Well, thank you.
Mm-hmm.
We have time for one last question. Go ahead, yeah.
Hi, I'm Vicki Nix. I'm currently a student in digital production and have been working a few freelance jobs, but as I get into it more, I am appreciating the liability that I may be opening myself up to, so I want to double check. This is not really a copyright question, but I think there's liability, and so maybe you can steer me in the right direction. If I have been contracted to video an event, and at this event are people from all walks of life, and it's a party, and there's a band playing, and there's music playing, am I opening myself up that I've produced a video with someone else's work and music playing on it?
Super good question. And this is the part of the presentation where my malpractice carrier says, nothing I tell you in this presentation should be taken as legal advice. You know, you see it on all my emails and on our firm's website, so I might as well indoctrinate you to it here. But you're right to be sensitive to that issue. The issue of background music in video production is a major copyright issue these days. I'll give you an example. Remember I was talking about Content ID and YouTube, okay? There's been a huge uproar amongst the video gaming channels on YouTube because there's a scene in a popular video game. Take Grand Theft Auto, right? Where they're driving the car, and the car has a radio that's playing music in the background to what's going on during the video game. They're playing the video game and providing simultaneous running commentary, which is usually why people actually tune in to watch the video. This doesn't have anything to do with wanting to listen to the background music that's playing on the video car that's being driven at the time. But Content ID catches that background music, flags it, and immediately gives the artist that recorded it or his recording studio the right to start taking the ad revenue off of that video. It's preposterous in my view that's the fast resolution of the problem that YouTube has come up with. Because if they didn't have Content ID, there's no way that those copyright owners would be chasing these small-scale infringers. But technically, it is a copyright infringement, potentially. Now, query, how many times has the band that's been playing at this particular party ever been pursued for a public production of the music that they're covering, right? Probably none. So by extension, how many times are we likely to see the owners of those rights pursue a video maker who's making a video where some of that music is being played in the background? Practically speaking, I don't think it's a big problem. Technically speaking, it's a problem.
Would it be better to get permission from the owners of the music, if you can obtain that, to tack it on after the fact, or? Of
course, but at the same time, I sometimes believe that what Napoleon said about China is what you should say about recording industry magnates. There lies China, a sleeping giant. Let her sleep, for when she awakes, she'll shake our world. You don't need to necessarily go kick the dog that's asleep and unaware of what's going on.
Thank you.
All right, thank you, Steve.
I'll hang around if anybody's got any more, advanced copyright problems or law school exam issues for me.
Thank you, Steve.
Yeah, you bet.